For centuries, the rule for deciding the validity of wills was that the courts required strict compliance with the Wills Act. So any deviation, no matter how trivial or unimportant, was enough to cause a will to fail. And you've read Pavlenko's estate. You can see that in that case, the testators did everything right. They went to a lawyer, they followed his advice. There was a slip, 2 wills were switched, but nobody was harmed by the slip, and there's no indication that the outcome that the testators were being cheated in some way. So in a first attempt to correct this problem, the drafters of the UPC suggested a doctrine of substantial compliance. That is, it was sufficient for a will to substantially comply with the Wills Act, and substantial compliance was defined as if the execution satisfied the purposes of the Wills Act formalities, the purposes being to protect the testator. This attempt on the part of the UPC failed because courts interpreted substantial compliance so narrowly that they hardly allowed any deviations whatsoever from the terms of the Wills Act. The courts interpreted substantial compliance to mean very near compliance. So they applied a near-miss standard. If almost all of the formalities were complied with, then the will could be probated. But their interpretation of what was a near miss was incredibly narrow. So here are some examples of the sort of things that the courts let through. Instead of 2 witnesses, the will was signed by 1 witness and notarized by a notary. Well, that's so close to having 2 witnesses that it was hardly a concession on the court's part. Well, the jurisdiction had a line of sight test for presence, but the witnesses were only in each other's conscious presence. That was considered sufficient under substantial compliance. Or the jurisdiction required witnesses to sign in each other's presence, but one only acknowledged his signature to the other instead of actually signing in the presence of the other. That's the Wade case. So in other words, substantial compliance was interpreted by the courts to mean 99% compliance with the Wills Act. So the courts interpreted the substantial compliance doctrine so narrowly that it achieved almost nothing. And the drafters of the UPC had to come back and spell out exactly what they'd meant the first time, but they had to give it a new name to distinguish it from the now adopted but misunderstood substantial compliance doctrine. They came back with harmless error. And this doctrine is that the court should probate the will if there's clear and convincing evidence that the testator intended this document to be his will. Langbein points out, and I'm on page 175 of the book now, that most of the failures of wills happened because of problems with the attestation clause, because of problems with the witnesses not being within a line of sight or in the conscious presence of one another, or there being only one witness or one being perhaps interested. And the reason we have the attestation clause, we have the witness signatures, is to protect the testator against fraud and duress. But fraud and duress is a problem in very few cases. And here it seems as though the solution, that is almost strict compliance with the attestation requirement, is worse than the problem. Therefore, the UPC came back and said, let's relax, especially problems with the attestation of the will. So we still require a document to be in writing. We will almost never, maybe never, probate a will that doesn't have a signature, but we will be more relaxed about the attestation requirement. And as a further explanation of how the UPC saw this, they said, we're especially going to let wills through if we know what happened, if we know why things went wrong. Think of the Pavlenko case. It's patently clear because it's stated in the case exactly what went wrong there. Everybody was trying to do the right thing. There was no fraud or duress. The lawyers slipped up, and we understand what went wrong. It had nothing to do with lack of intent or fraud. And let me give you another example. In Australia, There was a case where someone was about to commit suicide. He sat down at his kitchen table, he wrote out his will and he signed it, and then he shot himself. Australia doesn't allow holographic wills, so this will didn't comply with its Wills Act. But the court says, we know what happened. We know why he didn't get witnesses. There's no danger here that he was being defrauded or under duress, and we will let this will through, even though it doesn't comply with the Wills Act. That's what the harmless error doctrine is about. It occurs to me that I've twice mentioned the role of notaries, and maybe some people don't know what a notary does. The first time I mentioned it, well, I didn't really draw attention to it, but under the UPC Wills Act, I did talk about the provisions for the attestation that the witnesses could sign independently of one another and at separate times. The other option under the UPC for attestation is that the document is notarized. So you could have a notary validate the document instead of having witnesses. The second time I mentioned a notary was under the substantial compliance doctrine, where I said the courts stretched, and I'm being ironic here, stretched so far as to let a will through that was signed by a witness and notarized. So a notary, I put it right here on the slide, an official whose duty is to screen the signers of important documents for their true identity. And this is what a notary's, this picture is what a notary's seal and signature looks like. Jane Doe Notary Public attests that the person who signed the document identified himself to her. So now we step through the looking glass and into the area of holographic wills. We've gone to such trouble to show that the Wills Act formalities are applied incredibly strictly and there are no excuses unless you're in a UPC state. And now we see that the document on the screen before you counts as a valid will in states that allow holographs. What is a holograph? A holograph is a will that's written entirely in the testator's handwriting and signed by the testator, but is not witnessed. If it was properly witnessed, it would be an ordinary will. Right? The mere fact that something is handwritten doesn't make it not a good will. Up until the invention of the typewriter, all wills were handwritten. So the handwriting isn't the really distinctive thing. It's that it's entirely handwritten and not witnessed. And this is allowed in a portion of the states, about half. Essentially, the handwriting itself is considered evidence of genuineness. It serves some of the functions of the witnesses in the Wills Act because handwriting is identifiable as belonging to an individual, and therefore it protects against forgery or the danger of forgery, fraud, and to a certain degree incapacity, since you can't formulate a will if you really lack capacity. The more handwriting there is, the more confident the court can be that these are the testator's own words. Where on earth did this idea come from? Not from England, that's for sure. England wouldn't allow a holographic will. The origin of holographic wills is French. It's from the Napoleonic Code, and it comes to us via the French and Spanish colonies in the Southwest. So this is the New Orleans version of wills and estates. It's anything goes. Well, not quite. So the fact that this originated in the former Romance language portions of the United States explains why holographs are permitted in about half of the states, mostly in the West and South, some eastern states that thought it was a good idea, and that includes New Jersey. Not New England, of course. They're much too uptight there. The rules regarding holographs differ from state to state. So even in this area of reduced requirements, there are statutory differences. There are stricter and looser requirements. One of the problems is with testamentary intent. The problem is that a holographic will might not look like a will. So we have to look harder to find the intent to make a will element. And here I emphasize again that we need both the intent to make a posthumous gift and and the intent that this document be the will. So any old letter or jotting in a notebook can show intent to make a posthumous gift. You could write down, remember, on Tuesday I want to make a posthumous gift. But that's not a will until you intend this document to be the will. Then as to formalities, the document must be entirely in the testator's handwriting and signed by the testator himself, not by another on his behalf. States differ on whether the document has to be dated or not. Okay, where states allow holographs, this is a complete will. Note that it doesn't say last will and testament. Think for a moment about what is the evidence of testamentary intent and intent that this document be a will. That is, by testamentary intent I mean here intent to make a posthumous gift and intent that this document be a will. For illustrating the problems caused by holographs, the paradigm case is Kimmel in the textbook. The reason that this is in the book is obviously not to illustrate how to write a holographic will. It's here to show you what kind of informal documents are brought to the probate court as supposed wills, and how the court decides whether the testator did or did not intend this document to have legal force. And we're going to discuss this in class. But when you read it, think about how the court decided that this was a will, even though it looks like just a letter. And hint, all we need is writing, signature, and intent. Where is the intent? And think about intent for what? What did Kimmel have to intend for the court to find this to be a will? Okay, so let's look at this requirement that the document be entirely in the handwriting of the testator. The oldest rule was that if the will tried to incorporate any printed matter or anything written in someone else's handwriting, it was void as a holographic will. And there were some ridiculous applications of this rule. On page 208, there's the case in which someone wrote out his will, but he used his rubber stamp to indicate the name of his house, Craigthorne. The court said that printed, that is stamped word, Craigthorne, was intended to be part of the will, therefore the whole thing fails. Now, by part of the will, they mean anything that was meant to be part of the text of the will. Extraneous stuff like letterhead didn't count. It was called surplusage. So in this example, the White House, the words the White House are surplusage. They're not material to the will, and they can be ignored. So this doctrine forced the probate court to ignore anything, any evidence of intent that was not in the testator's own handwriting. Here I would like to play a little interlude music, or perhaps you could go get a cup of coffee or something like that, because I want to separate my discussion of will forms from the whole idea of holographs for now. We've been doing holographs, we're going to talk about will forms, then we're going to talk about the two of them in conjunction, but for the moment, pretend that we haven't been talking about holographs. They're temporarily irrelevant. The thing about will forms, you used to be able to buy them at any old place that sold stationery or office supplies, and maybe they are now going the way of the dodo, and people are just going to use software. Now, will forms are perfectly okay. If you follow the instructions, you have a valid will. The instructions tell you how to hold a will execution ceremony. Obviously, that's a necessary part of writing a will. This will that I'm showing you on the PowerPoint has all of the necessary elements. It has a statement of intent, it has bequests, it has the date and the signature, and it has the witness signatures. This document is not a holograph or an attempted holograph. Bits of it are handwritten, but what makes a holograph is that it's handwritten and not witnessed. A witnessed will is an ordinary will. That's what we have here. Whether the body of the will is typed or handwritten or half typed and half handwritten. Got that? Okay, this slide speaks for itself, I think. The one pitfall of a will form is that people might not read the instructions. and then they missed the bit about witnesses. So then some lawyers had a brilliant idea. What if, in effect, the handwritten portion of the will included all of the necessary elements of a holographic will? What if we could treat the form as surplusage? Not this one, of course. Here, critical elements are printed. But look at the will on the top of page, or on page 205, as an example of a will form that contains an awful lot of handwriting, maybe enough handwriting to constitute a holographic will. The problem with will forms, of course, is that they do all the work for you. So it says last will and testament across the top, and it says I so-and-so hereby make my last will and testament, and it's fairly unlikely, or at least it doesn't always happen, that someone happens to include language of testamentary intent in his own handwriting. In filling out the form, he fills out the bequests, but misses that critical element of a will. So the UPC did its common sense thing, and it suggested that a will form that is not executed, that is not properly witnessed, could be treated as a holograph if the signature and material provisions are in the handwriting of the testator, even though immaterial parts such as the dates or introductory wording be printed. Well, you'll see what happens. Here it is. Courts did what courts do. They said, oh, material provisions means anything necessary to the will. If the printed portion faded away, if we treated it as surplusage, the handwritten portion that remained would be a full will, with the statement of intent and the bequest to legatees and the signature. So a sufficient will under these circumstances would be as here on the slide. I give, devise, and bequeath all of my estate to Daryl. Unless you have all of that on the will form, then it will fail as a holograph. So basically, they reverted to the doctrine of surplusage. That is, if everything faded away apart from the testator's handwriting, you would have a complete will. And here's the UPC's exasperated new attempt. When we say material bits, we mean beneficiaries and bequests. Intent can be established from extrinsic evidence, like the fact that it's not written on a will form, dummy. So again, they spelled it out. Material portions are beneficiaries and bequests. Unfortunately, various jurisdictions were using their great old name, material provisions. They had to think of a new name. They called this the material portions doctrine. That is rather confusing because the material provisions and the material portions doctrines are really quite different. So I look forward to seeing you in class.